We have held that the judgment of the 7-judge bench in Synthetics and Chemicals Limited versus State of UP is wrong on certain aspects and have overruled the judgment to the extent that is indicated in this judgment. Justice, my learned sister, Justice B.V. Nagaratna, in her separate opinion, disagrees with the opinion of the majority on specific aspects. The following were the issues which fell for our adjudication while deciding the correctness of the judgment in Synthetics. A, whether entry 52 of list 1 of the 7th schedule to the Constitution overrides entry 8 of list 2. B, whether the expression intoxicating liquors in entry 8 of list 2 of the 7th schedule to the Constitution includes alcohol other than potable alcohol. And C, whether a notified order under section 18G of the Industries and Development Regulation Act is necessary for Parliament to occupy the field under entry 33 of list 3 of the 7th schedule to the Constitution. The issues are answered as follows. The expression "that is to say" in entry 8 of list 2 cannot be interpreted to circumscribe the scope of the entry. The words that follow "that is to say" are illustrative and explanatory of the scope of the provision. The expression does not limit the scope of the entry. Thus, the scope of entry 8 of list 2 cannot be limited to the production, manufacture, possession, transport, purchase and sale of intoxicating liquor. Entry 8 in itself indicates that the intent is to ensure that it is read as broadly as possible. The entry seeks to regulate everything from the stage of the raw materials to the consumption of intoxicating liquor. Entry 8 of list 2 includes both the industry and the product of intoxicating liquor. The power of Parliament in entry 52 of list 1 is defined by the phrase control. The entry does not read as industries declared by Parliament by law to be expedient in the public interest. The entry states industries the control of which by the Union is declared by Parliament by law to be expedient in the public interest. The law enacted by Parliament must not be an abstract declaration, but must specify the extent of control that is necessary to be taken in public interest. The state legislature will have the competence to legislate with respect to the field which is not the subject matter of control. The legislative competence of the state legislature is only denuded to the extent of the control by the Union declared by the law of Parliament to be expedient in the public interest. Irrespective of whether the term industry is interpreted in a narrow or a wide manner, a point that is vehemently contested by both sides, the industry of intoxicating liquors specified in entry 8 cannot be taken over by Parliament under entry 52 of list 1 for the following reasons. And we have given reasons. The general principle is that legislative lists must be interpreted widely. The question what the court must pose is whether the two entries would overlap when interpreted widely. Then B, the only limitation in entry 52 is that the control of the industry by the Union must be necessary for public interest. Parliament can legislate on any industry provided it satisfies the condition prescribed in the entry. Thus, entry 52, when read independent of any other entry of list 1, list 2 or list 3, does not preclude the inclusion of industry of intoxicating liquor, provided that the Union is able to prove that its control is necessary in the public interest. Similarly, entry 8 of list 2, when read independently, also includes inter alia the production, manufacture of intoxicating liquor, which is included within the meaning of industry. Thus, entry 52 of list 1 and entry 8 of list 2 overlap on the aspect of industry of intoxicating liquor. Entry 8 of list 2 is not subject to entry 52 of list 1. Thus, the state legislature has the exclusive competence to enact a law on the field in entry 8. The court must distinguish between entries that are expressly subject to entries in the Union list and entries that are not. When one entry is not subject to the other, the court must harmonize the overlap of entries. The only way to reconcile the entries is either to exclude the industry of intoxicating liquor from entry 52 of list 1 or entry 8 of list 2. The court, while reconciling the provisions, must ensure that neither of the entries is rendered redundant. E. Entry 52 of list 1 is a general entry dealing with industry. Entry 8 of list 2 is a special entry dealing with one particular industry. The consequence of interpreting entry 52 to cover the industry of intoxicating liquor is twofold. First, it would amount to deleting the word production and manufacture in entry 8. And second, the state legislature also loses its exclusive competence to legislate upon the product of the industry, rendering entry 18.8 fully redundant. As a consequence, it is clear from the analysis of the judgments in F.N. Balsara and Southern Pharmaceuticals that the meaning of the phrase intoxicating liquor in entry 8 of list 2 has been expanded beyond the narrow definition of alcoholic beverages that produce an intoxicating effect upon consumption. Liquids which may contain alcohol and which can possibly be used or misused as intoxicating liquor have been included within the meaning of the phrase. The interpretation based on legislative meaning elucidated in Gannon Dunkley, which narrows the interpretation of entries, thereby creating an exception to the rule of wide interpretation, should only be employed by courts when the twin tests highlighted above are fulfilled. The tests are A, the phrase should have acquired a well-recognized, definite and precise meaning in law, and B, the legal import of the word must be practically unanimous. Additionally, we are of the view that the legislative meaning interpretation should be adopted only when the deviation from the popular meaning of the phrase is not too wide. The legislative meaning cannot be used to artificially narrow legislative entries. The definition of liquor in pre-constitutional statutes as liquids containing alcohol cannot be transposed to interpret the legislative entry. The phrase used in the legislative entry is intoxicating liquor. The definition of one part of the expression in statutes cannot be used to interpret expressions that are used to indicate a collective meaning, particularly when the common parlance definition starkly varies. The common parlance meaning of intoxicating liquor means liquor which causes intoxication, that is, which causes someone to lose control. Thus, the three-pronged test to identify if intoxicating liquor has acquired a legislative meaning has not been satisfied. And the Constitution uses three distinct expressions relating to alcohol: intoxicating liquor, alcoholic liquor for human consumption, and intoxicating drinks. The evolution of the entries in the legislative list indicates that it was a conscious decision to substitute alcoholic liquor with intoxicating liquor in the regulatory provision. It was also a conscious decision to use different phrases in the taxing entry and the regulatory entry. We do not think that it is necessary for us to lay down the contours of different phrases used in the Constitution. That is a decision for another day and in another case. However, it is still possible to draw some inferences from the different uses. The expression alcoholic liquor for human consumption and intoxicating drink are used in the context of consumption. However, the provision relating to intoxicating liquor is not limited to its consumption. It stretches to its production, manufacture, possession, transport, purchase, and sale of intoxicating liquors and beyond. The second difference is the use of the expression intoxicating instead of alcoholic as the adjective to liquor. The following inferences can be drawn from the above differences. A. Alcoholic liquor defines the scope of the provision based on the ingredient, that is alcohol. In contrast, intoxicating liquor defines the scope of the provision based on the effect, that is intoxication. Thus, even liquor which is colloquially or traditionally is not considered as alcoholic liquor may be covered by the phrase intoxicating liquor if it produces the effect of intoxication. B. Intoxicate means the ability of someone to lose control of their behavior. It could also mean poison. Thus, the purpose of substituting the adjective which indicates the ingredient, alcohol, with the impact intoxication seems to be to enhance the scope of the entry to cover liquor which has an impact on health. And C. The public interest purpose of the provision is evident from the accompanying word from the provision, which includes every stage from its production to consumption within the scope of the entry. The public interest purpose of the provision is also evident from the evolution of the entry. The relevant entry in the 1935 Act also regulated narcotic drugs and opium along with intoxicating liquor. References to narcotic drugs and opium were deleted to prevent its overlap with entries in the concurrent list. As highlighted in the previous section, a common thread that runs through alcohol, narcotic drugs, and opium is that they are products which can be noxiously used because they are also used as raw materials in the production of other products. It is clear from the above analysis that the meaning of the phrase intoxicating liquor cannot be restricted to potable alcoholic liquor, that is, alcohol that is sold as a beverage. Alcohol is an inherently noxious substance that is prone to misuse, affecting public health at large. The purpose of entry 8 is to cover alcohol that could be used noxiously to the detriment of public health. The entry covers all alcohol that could be prone to noxious use. It also covers variants of alcohol that are not used for the preparation of potable alcohol, but which could be misused to harm public health. This interpretation is in consonance with the mischief sought to be covered by the entry. Thus, while the entry covers ENA and rectified spirit, which are used in the preparation of potable alcohol, it also covers variants of alcohol, such as denatured alcohol, which though are not used in the preparation of potable alcohol, are prone to be misused. Item 26 of the first schedule to the IDRA must be read as excluding the industry of intoxicating liquor as interpreted in this judgment. The holding in Tikaramji is not relevant to the dispute for the following reasons. We have interpreted the phrase intoxicating liquor in entry 8 to include ENA since it could be noxiously used. And, notwithstanding the above, if the ground for overruling the holding in Tikaramji is that manufacture or production cannot be disconnected from raw materials, it would also equally apply to the industry of intoxicating liquor covered by entry 8 of list 2. We have concluded that the words that is to say in entry 8 are illustrative. They are not exhaustive of the contents of the entry. Thus, entry 8 cannot be interpreted to exclude raw materials used for the production of intoxicating liquor merely because the entry does not expressly provide for them. On an application of the principle that entries ought to be interpreted widely, the raw materials for the production and manufacture of intoxicating liquor, as interpreted in this judgment, will be covered by entry 8. The issue of whether Section 18G of the IDRA covers the field of entry under entry 33 of list 3 does not arise for adjudication in view of the finding that denatured alcohol is covered by entry 8 of list 2. The reference is answered in the above terms. The registry is directed to obtain administrative instructions for placing the matters before the appropriate bench. Synthetics as indicated in the judgment.
Management that states can levy a fees or
state has to have a very good
I have perused the comprehensive and erudite opinion authored by Honorable the Chief Justice of India, Dr. Dhananjay Y. Chandrachud, on the questions referred to this 9-judge bench. I respectfully dissent on certain aspects of the said opinion and express my reasons therefore. The sum and substance of all the questions referred to this bench could be crystallized on the short point for consideration, namely whether the expression intoxicating liquors in entry 8 list 2 of the 7th schedule of the Constitution of India includes within its scope and ambit industrial alcohol, and consequently whether a state legislature has the competence to legislate on industrial alcohol. My short answer is that there is a lack of legislative competence in the state legislature when viewed from the constitutional framework and statutory framework of Industries Development and Regulation Act 1951, for short IDRA, passed by the Parliament on the strength of entry 52 list 1 of the 7th schedule, and having regard to section 2 of the said act, read with its various provisions and the first schedule thereto, particularly item 26, which deals with fermentation industries other than potable alcohol. However, the discussion on scope and ambit of entry 33A list 3 of the 7th schedule of the Constitution is distinct and shall be discussed later. Therefore, Synthetics and Chemicals Limited has been correctly decided by the 7th-judge bench of this court on the aspect of section 18G of the IDRA occupying the field, and consequently whether the state legislatures are denuded of their powers on the content of the subject matter of the said section in the context of entry 33A list 3 as per the first part of article 254(1) shall be adverted to later. I propose to discuss reasons for the aforesaid view. I have a lengthy judgment and therefore a lengthy index with 24 points, and they may be perused. Analysis. The survey of the aforesaid decisions of this court and their analysis clearly indicate the golden thread of continuity in all of them. That is, this court has been clear on what is meant by the expression industrial alcohol, as simplified to refer to all alcohol which is not fit for human consumption as a beverage or non-potable alcohol. By contrast, the use of the expression potable alcohol refers to intoxicating liquors used for human consumption as a beverage or as a drink. However, in paragraph 85 of Synthetics and Chemicals, the expression both potable and is an inadvertent insertion inasmuch as there was no reason to state that licenses to manufacture potable alcohol was vested in the central government. Therefore, to that extent, the judgment in Synthetics and Chemicals calls for clarification. The judgment of this court in Synthetics and Chemicals was also clear about the controversy before it, namely the competence of the Uttar Pradesh state legislature to impose rent fee on industrial alcohol when the same is a product of fermentation industry and therefore under the control of the union. However, the sum and substance of the controversy has to be answered by this court on the premise that despite there being clarity in the minds of the authorities under the states as well as the center, repeated imposition of imposts in the form of tax or excise duties have brought several cases before this court for adjudication. Ultimately, those who are in the business of industrial alcohol or intoxicating liquors, namely non-potable and potable liquor respectively, are clear about the nature of their business and the products that they are dealing with. Hence, I feel that it is incumbent for this court to enhance the clarity and not create a further legal regime which would cause confusion and legal uncertainty in the economy. At the outset, I may refer to Cooley's constitutional limitations. Quote, in interpreting clauses, we must presume that words have been employed in their natural and ordinary meaning. Says Chief Justice Marshall, quote, the framers of the Constitution and the people who adopted it must be understood to have employed words in their natural sense and to have understood what they meant, unquote. This is but saying that no forced or unnatural construction is to be put upon their language. And it seems so obvious a truism that one expects to see it universally accepted without question. But the attempt is so often made by interested subtlety and ingenious refinement to induce the courts to force from these instruments a meaning which their framers never intended. That has frequently become necessary to declare this fundamental maxim. Therefore, one task before this court is to ascertain to what extent intoxicating liquors has acquired a natural and ordinary meaning at the time of the Constitution coming into force. In my view, what is required to be seen is the nature of the product which leads to such an intoxicating effect upon human consumption of the same. Here, the expression consumption must be explained. It is not all kinds of human consumption, direct or indirect, which is the determining factor. It is only direct consumption, that is as an ingestion by the act of drinking as a beverage or a drink. An indirect consumption by use of alcoholic liquors as a raw material for any other product, industrial, medicinal or a toilet item, cannot be included as part of Entry 8 List 2. Secondly, merely because there can be a potential misuse of industrial alcohol, for example, by converting rectified spirit as a beverage, which has an intoxicating effect, Entry 8 List 2 cannot be stretched to include such industrial alcohol. The prevention of abuse of industrial alcohol as a beverage is also covered under Entry 8 List 2. Thus, what is carved out of fermentation industries in Entry 24 List 2 is only intoxicating liquors used as a beverage and thus for direct human consumption. The said subject is placed in Entry 8 List 2. This would imply that the rest of fermentation industries would be within the scope and ambit of Entry 24 List 2, which is subject to Entry 52 List 1 and is a scheduled industry as per Section 2 read with Item 26 of the first schedule of the IDRA. One must also be cognizant of the fact that Entry 8 List 2 concerns itself with intoxicating liquors, even from a historical perspective. One must note that the construction of Entry 8 List 2 should not potentially give the states the legislative competence to legislate on industrial alcohol, which is a scheduled industry under IDRA. That entry 8 list 2, which deals with intoxicating liquors, cannot also subsume industries for manufacture of industrial alcohol, etc. Viewed from another perspective, the exception, that is the mischievous use, cannot lead to governing of the norm, original intended use, through such construction of entry 8 list 2. Put into practice, this would translate into legislative regulation of production, manufacture, possession, transport, purchase, and sale of the entire industry and product of industrial alcohol only because of its possible misuse or mischievous use. This reading would be tantamount to attaching to the constitutional intent an absurdity, that is the part governing the whole, or in other words, bringing within the ambit of entry 8 list 2 something which is an exception as a main aspect of the entry. A power to legislate as to the principal matters specifically mentioned in the entry also includes within its expanse legislation touching incidental and ancillary matters. However, ancillary matters by a backdoor cannot be included within the entry beyond what is covered as the principal. Herein, the ancillary matter being prevention of mischievous use of industrial alcohol would be within entry 8 list 2, but industrial alcohol as such would not be included. Merely because industrial alcohol by a process can be converted to alcohol for human consumption as a beverage, that does not mean that the state legislature can regulate industrial alcohol. On the other hand, the states as per entry 8 have the power to regulate intoxicating liquors, which is for human consumption as a beverage, and is in that regard have the power to prohibit industrial alcohol being converted to alcohol for human consumption as a beverage. This is in order to protect the health of citizens, which is a direct principle of state policy and Article 47 of the Constitution, and in order to prohibit unauthorized use or misuse of industrial alcohol produced in the state from being converted and sold as intoxicating liquors meant for human consumption as a beverage. Then I have looked at the matter from another perspective. One of the contentions raised in this batch of cases is with regard to whether the central government has to, in fact, issue a notified order with regard to regulating the supply and distribution and trade and commerce of any article or class of articles relatable to any scheduled industry, so as to indicate that the state legislature cannot pass any legislation under entry 33A list 3. In my considered view, the fact that an industry is a scheduled industry under the IDRA would imply that at the time the central government is empowered to, at any time the central government is empowered to issue a notified order providing for regulating the supply and distribution and trade and commerce of the products of such a scheduled industry. But in the absence of there being an issuance of a notified order as such, can the state legislature be denuded of their powers to pass any law under entry 33A list 3? Having regard to the emerging situation in the economy in the matter of supply and distribution and trade and commerce of the articles or class of articles related to any scheduled industry, the central government may issue a notified order for the purpose of regulating the same so as to secure its equitable distribution and availability at fair prices of the product of such industry. Situation may suddenly arise, make or expedient to issue a notified order under section 80G of the IDRA. One cannot envisage the emerging circumstances in an economy such as the Indian economy where the need for issuance of such a notified order would arise. It could be, for instance, to curb hoarding and black marketeering of a particular article of a scheduled industry in order to stifle price rise. It could be for ensuring a minimum or maximum price for any article related to a scheduled industry, which is a raw material or ancillary input for a product or article of another scheduled or non-scheduled industry. Sudden rise in prices of commodities or articles relatable to any scheduled industry due to natural disasters, floods, famines, financial emergency, or such other reasons could necessitate issuance of a notified order under section 80G of the IDRA. Of recent occurrence is the COVID-19 pandemic, which would have necessitated issuance of notified orders on certain articles relating to scheduled industry. The field of legislation must therefore be left open for the central government to act by issuance of a notified order as and when thought necessary or expedient to secure an object stated in the said provision. But can it be held that in the absence of any such notified order issued by the central government, the states could pass laws under entry 33A list 3? Would it lead to a legal confusion and an overlapping and contradiction? This is because if it is held that in the absence of there being a notified order actually issued by the central government under section 18G of the IDRA, the states are empowered to pass laws under section entry 33A list 3, and such laws are in fact made under the aforesaid entries by the states, and the central government subsequently decides to issue a notified order under section 18G of the IDRA. The question would be, what would be the fate of the laws made by the state if they overlap with the notified order issued under section 18G of the IDRA? Obviously, the control of any industry being taken over by the union under the provisions of the IDRA would imply that the central government is empowered to issue a notified order in terms of section 18G of the Act, and that when it is necessary or expedient to secure the equitable distribution and availability at a fair price of any article related to any scheduled industry. In such a case, the notified order being issued under 18G of the IDRA would have an overriding effect on the state's laws, if any made under entry 33A list 3 in regard to trade and commerce, etc. A law made by the state under any entry of list 3 or concurrent list is no doubt subject to Article 254 of the Constitution. However, entry 33A list 3 is a very unique entry in as much as the said entry would have to be read in the context of entry 52 list 1, which relates to IDRA, which is enacted by Parliament, and under the said entry, inter alia section 18G of the IDRA exists. When entry 52 list 1 and any law such as IDRA empowers the union or central government to take certain steps under the provisions of the said act, it would imply that the state legislature is per se denuded of its powers to make any law under entry 33A list 3. Applying the above interpretation, when once the central government has the powers under section 18G of the IDRA in the matter of regulating supply, etc., then the field has been occupied by the central government to issue notified orders as and when necessary. I have brought this interpretation under the first part of Article 254(1), which says, if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact. In this case, the IDRA is a law which has been made by the Parliament. Therefore, I have said from 110/1953, the field has been occupied. Now, this is what in paragraph 85, synthetics and chemicals also says, where it says the state cannot claim that under entry 33 of list 3, it can regulate industrial alcohol as a product of the scheduled industry because the union under section 18G of the IDR has evinced a clear